is true if you're trying to use clips that you don't think would fall under the fair use doctrine, right? I mean, so those kinds of copyright negotiations can be very costly and time consuming and put real burdens on the use of copyrighted material in a project for no obvious sort of socially beneficial reason, right? Yeah. I mean, other than engaging, other than providing a revenue stream for the copyright owners. But what I always think is interesting, is that we think of these kinds of uses as being kind of paradigmatic situations where you have to think about fair use, and yet the reality is that in practice, in so many alternative contexts, we do fair use all the time and take it for granted, right? So, and the example I always use is, like, for example, as law professors, I write an article and I insert quotations from other people's articles and other people's sources. And no one says to themselves, oh, gee, I better go out and make sure I get permissions for all of those quotations, right? Those are just
part of the law. Right. It's part of the law, and it's part of the law. It's fair use. But also we as a community, a society, says that's just what we do. You can borrow from bits and pieces of people's writings to put quotations in. We teach our children that in school, right? So that's interesting.
But what I think is especially interesting about that, though, is that the social context in which particular forms of use are taking place structures whether or not people can actually see what they're doing, right? When people are making a movie, or when people are, making a song and using sampling or something like that, we've created a social context in which there's an ownership norm and a permissions culture, right? So we say, okay, when you're doing this kind of cultural production in this cultural area, you have to think about copyright and you have to think about licensing, right? But then there's this other context, right, where you're doing functionally exactly the same thing, right? But we don't see it as requiring the same kinds of thought process, right? So people don't even conceptualize that as being a fair use question in the first place, right?
Right. What's really interesting is copyright is really complicated. Like, we spent years of our life studying it. But in some way, communities have social norms and they get it. Like, right of attribution. Like, we don't have, it's not necessarily a legal thing, but people are like, well, I borrowed that from that person and I should probably include that or not, right? And each group has their own social norms that the law seems to sort of get. So, thinking about this, like having this go out to people who are, art quilters or quilters in general or artists in general, like, I feel like they shouldn't be super scared of. Oh, okay, cool.
Sorry, does that work or not?
Yeah, that totally works. Cool, thanks. Hold on 1 second. So my thought was sort of like, how do we explain to them, sort of, don't be scared of copyright, right? Are you be within the social norms of your community. Mm-hmm.
Yeah.
And what is that? And that's what the project's looking at, right?
I think that's right. I mean, I think that social groups almost inevitably seem to come up with, among other kinds of rules, when relevant, ownership rules relating to expressive production that are unique to those particular social gatherings. And I think in addition, you're right that in most social groups or most kind of most kind of collective engagement with cultural production of that kind, those internal norms are more salient and more relevant than the kind of formal ownership rules adopted by copyright, which often often those copyright rules are not really intended for or even contemplate the kinds of production that these more insular groups are generating. And I'll often say to artists or filmmakers who become worried, about the potential for copyright infringement and so on, that really, in many cases, the best thing that could happen for your career would be if someone were to sue you for copyright infringement.
Well, I mean, and there's some weird cases where you're like, well, why did that happen? You're like, this seems very odd to me, right? I think it does catapult
well, and so
people,
Gene Fomer was giving at WIPIP last week. She gave a great presentation on a paper she's doing with Amy Adler, really pointing out that, like, for example, when Richard Prince created his Instagram painting series, a bunch of the people whose Instagram posts, some of them people were thrilled, other people whose Instagram posts he used were peeved about it and either threatened or actually did file infringement actions against him, or sort of started their own campaigns to sort of object in one way or another to what he was doing. But from a purely objective standpoint, right, that was the best thing that had ever happened to them, right? I mean, all of a sudden they were in the spotlight and people knew who they were, right? I mean, to the extent that what you're trying to do is build a brand for yourself as an artist, nothing's better than somebody giving you free publicity, right? Like old Oscar Wilde quote, right? The only thing worse than being talked about is not being talked about. Right? The one caveat that I would offer, and I think it's an important one that often gets forgotten in discussions of informal property norms, especially in a kind of quasi-IP context, is that just because social groups develop internal social norms doesn't necessarily mean that those internal social norms are for the best.
Right. I totally agree. I mean, that's kind of
the fact that they exist doesn't necessarily mean that they're justified. And I think it's always really important to ask essentially who benefits from this social norm in question, and are there costs associated with it that the people who are benefiting don't bear themselves?
Right. Well, that's kind of what the project's trying to understand. Is what's cool about the quilting industry is that you've got the commercial side of it, you've got the average person side, you've got the art quilts, and then you've got the guilds, which are super interesting in the sense that there's a group of people meeting and making a pattern, and where does that pattern come from, and is it a public domain pattern, is it something that they've gotten permission for? So again, I think thinking through, that's why this project I think has gotten bigger, because it's a more complicated ecosystem than say the poet, right? So that, or the even different industries that don't have the inventions and the tools, and I mean, it's just this crazy space of intellectual property where mostly cultural norms are I think, be nice. Just make sure that saying what are the rules of the game in this industry and this community, and sort of what role does custom and law play within that?
And honestly, it's a community that I'm only slightly familiar with, and I'm learning a lot more about through your work, which is fascinating. And the one thing that kind of struck me from looking at what you're doing and from talking to the Weavers Guild.
Right, so this is how we connected, because you had to give a presentation to the Weavers, and I'm like, hey, I know a bunch of stuff, and I'm curious what they think. So you went to talk to Weavers, and what were they saying?
Yeah, so one thing that struck me, especially now kind of in retrospect, reflecting on it, was that the trouble cases, to use a kind of Llewellyn turn of phrase, right, that they seem to be wrestling with were often circumstances where they were moving from an artisanal mode of production into an increasingly commercial mode of production, right? So they had a lot of questions and uncertainty about what kinds of, what kinds of copyright issues specifically, but also what the appropriate social norms would be surrounding the use of things like patterns, for example, right? Like, what can I do with this? How many can I make, right? What kind of ownership can people have in this kind of work of authorship, as it were? And I think that reflects sort of like sort of where copyright and quasi-copyright concerns start to become relevant is where you start to see a more and more liquid potential market for particular products, right? And so when you're dealing with unique objects, it seems to me that copyright, which is developed to really wrestle with, reproducibility and scale, economies of scale, becomes less and less relevant. But as you start to move into segments of a particular market that lend themselves more to reproducibility, you inevitably start to see copyright-related questions rising more and more to the surface. And especially when there's a kind of a mix of the two, I think that's where the questions tend to be hardest to answer in a sort of satisfying way.
Well, they're all really complicated. I think about, don't copy patterns, right? That's a really, but some patterns require you to make copies of them. Paper piecing, for example, tells you to make 50 copies of something or blow it up 200%. That's, so just blanket statements, simple statements aren't going to be helpful. But at the same time, I feel like, I think back to where we started, which was when I asked you, like, what role does copyright play in your creativity, in the process of creativity? You're like, it doesn't. So, like, how do we get to a place where people understand when it should matter and when it shouldn't matter? And that's kind of what the project is about. Right. And it's a little, there's nuance to it, but I think it's just a kind of physics. I always think about that there's a certain copyright physics, and once you understand it, then it all kind of makes sense. Yeah.
I mean, I would say my take is perhaps a little bit idiosyncratic, both as a maker and as a scholar, because I came to art. I came to law through art, and I came to art kind of in the context of a very appropriation friendly, kind of anarchistic model, right?
You guys are wild.
Yeah, so I tend not to think personally about copyright in heavily normative terms, which I think is, not unusual among copyright scholars perhaps, but rather unusual when it comes to non-copyright scholars perhaps. And so, I think I tend to be especially skeptical of sort of normatively laden claims about ownership, especially when people seem unwilling to reflect on and question those normative assumptions, right? Because I think oftentimes they can provide camouflage for kind of property claims that may not be fully justified, right? And I think we see it happen in ways that get kind of normalized and rationalized in many different contexts, right? So one that I've always found particularly interesting is, in an academic context, for example, right? Where, academics, practically speaking, through the use of plagiarism norms, create a quasi-ownership in, ideas or approaches that are much broader in scope than, and different in kind than the kinds of things that could be protected by copyright. And I'm not entirely sure that that's for the best, right? I mean, it might be, but it's not obvious to me that we should respect those kinds of claims.
Well, I think, like, sort of to add to this, I think the user-generated movement of everybody making everything, we're making a podcast, you're making, like, the ability of technology for us to make all kinds of stuff, photocopy, like all these things, has also changed the game and made things permissible that weren't like even 10 years ago. That there is